Good afternoon, everybody. My name's Amy and I am from Norfolk SEND Partnership, which is the SENDIAS service for Norfolk. So just in case you're not aware of what that actually is, it's the Special Educational Needs and Disabilities Information, Advice and Support Service, and every local authority does have one. So I understand there may be some people joining us today that aren't from Norfolk, but your local authority will have a service that's the same as ours. So if you need advice from them, please do seek them out. I'm just going to let there's a couple more people just join in, so I'm just going to let them in and then we'll make a start. So I've been asked to come and talk to you today about appealing EHCP decisions. We've only got 45 minutes and it's quite a complicated topic, so I've tried to keep it to a really brief guide. It won't be all of the information that you would ever need to appeal, but I would recommend you always just speak to your local SENDIAS or IPSI or another advice service if you need more advice. If you have any questions, if you could pop those into the chat function, and we will be answering all those questions at the end, if that's okay. And I'm happy to run through all of those at the end of the presentation. Okay, so first of all, I just wanted to talk a little bit about what is the SEND Tribunal. So the first tier tribunal, which is the Special Educational Needs and Disabilities, is an independent national tribunal which hears parents and young people's appeals against local authority decisions about the special educational needs of children and young people. And it's also the same tribunal that would hear any claims of disability discriminations against schools. And you can appeal to them if you're unhappy about a decision that's been made in relation to an education healthcare needs assessment or an education healthcare plan. There are no fees. It is a free service unless you choose to be represented by a solicitor, in which case there would be fees attached to that. However, you shouldn't need to be represented, and I will talk about that in a little bit more detail as we go along. So the SEND Tribunal has the power to order the local authority to carry out an EHC needs assessment. So if you've applied for an assessment and it's been refused, that's your first point at which you could appeal, and the tribunal judge can overturn that decision and order the local authority to do that assessment. They can also order them to issue education healthcare plans. So if you've had a refusal to issue, the judge can overrule that decision as well. They can order the local authority to amend existing EHC plans, and that includes the school named in the plan. So if you're not happy with the school that's been named in section I of the plan, that is something that the tribunal can also order on. The local authorities must comply with those orders once they're made. So it is a legally binding order, and the local authority does have to do what the tribunal judge decides. It's governed by the law, and they have to follow the interpretation of the law that the higher courts in judgments about previous SEN disputes have made. So sometimes you'll hear about things called case law, and that's where things have been taken to the upper tier tribunal, and then judgments are made to interpret what the law says, and then the first tier tribunal must use those judgments to help them in their decisions. The SEND Tribunal looks at all the evidence that is put before it. So it's an evidence-based process, and then it will decide on whether the local authority decision followed the law and the code, and then it will make the decision based on what is right for the child or young person at the date of the hearing. So these are the things that you can appeal. So refusal to assess. You can appeal refusal to issue once an assessment has been carried out. If a local authority then says no to issuing a plan, that can be appealed. You can appeal refusal to amend a plan following an annual review. You can appeal a refusal to reassess. If you've applied for a reassessment at any time and that's declined, that can be appealed. You can appeal contents of the plan. So the parts of the plan you can appeal are the Section B, which is where the special educational needs are listed, and Section F, which details the special educational provision that will be made available, and Section I, which is where the school or placement is named. You can also appeal the cease to maintain an EHCP. So if you've had an annual review and the local authority then sends you a letter to say the EHCP is no longer needed, then that decision can be appealed. And there is an ongoing national trial where if you are appealing an education part of an education healthcare plan, you can also appeal for recommendations from the judge on the health and social care sections as well. So the judge can't make orders on the health and social care section at the moment, but they can make recommendations, and they're very strong recommendations that a local authority would be expected to follow unless they could come up with a very good reason not to. So the people that can appeal are the person that has parental responsibility or the foster carer parent of a child if that child is between 0 to 16, or if they're over 16 but under 25, then it would be the young person themselves who is given the right of appeal. That's not to say that they can't ask you as parents or the person with parental responsibility to support them with that. If the young person lacks mental capacity, then a representative can appeal on their behalf, but that would have to be proven under the Mental Capacity Act that they don't have the capacity to make that decision for themselves. It's a big part of the first tier tribunal. Then you first have to consider whether to take part in mediation or not. So you don't have to actually go to a mediation meeting, but you have to make contact with the mediation service, and you have to then make a decision about whether or not you're going to have the mediation to try and resolve the issue before you lodge the appeal. So to lodge the appeal, you will need a certificate from the mediation service to say you've either taken part in mediation or you've spoken to them and decided not to. You've got 2 months to do that from when you get the decision letter from the local authority. So that letter would be either the letter that is sent to say they're refusing to assess your child or young person, that they are refusing to issue an education healthcare plan following assessment, the letter that comes with the final plan itself, or a letter following annual review. So the only 2 exceptions to the mediation rule are you can register an appeal without having to consider mediation at all if you are only going to tribunal about the name of the school or college named in section I of the plan, or if it's a disability discrimination appeal. So for all other appeals, you must speak to mediation before you lodge your appeal. So how do you actually lodge your appeal then? So once you've spoken to mediation, you would then need to fill in the SEND 35A or the SEND 35, and those are available from the gov.uk website. If you just Google SEND Tribunal, it will come up with the page with the forms and everything on it and instructions on how to do it. So it's a SEND 35A if the appeal is regarding refusal to assess, or a SEND 35 for all of the other types of appeal. It's better if possible to fill it in and send it electronically. The reason I say that is then you reduce the risk of things getting lost in the post. You get an immediate response to say that they've received it. It just is easier for tracking purposes, but it can be posted to them. But I would suggest that if you do post it, that you post it recorded delivery so that you've got evidence of what you've posted. This must be done within 2 months of the date of the decision letter that you are appealing, or the final education healthcare plan, or 1 month from the date that you obtain the mediation certificate. So those are very strict dates. Very, very occasionally the tribunal will allow people to go outside of those dates, but not very often. So it's really important that you remember that if you want to appeal the decision, you need to make sure it's within 2 months. You've actually lodged the appeal with the SEND 35 or the SEND 35A, either within 2 months of the date of the decision letter, or 1 month if you've got the mediation certificate. Whichever of those dates is later is the date that you must do it by. Along with the form, there are several things that you have to send, and if you don't send them, then you can have your application rejected and sent back, and you'll have to do it again. So the form must have with it a copy of the letter that the local authority has sent you that is gives you the decision that you're appealing, because that is what gives you your right of appeal. Your mediation certificate if necessary, so unless it's a section I appeal. your evidence supporting your arguments, although further evidence can be sent in at a later date, and a list of all the documents that you've enclosed. It's helpful if you can put the evidence in chronological order, but you don't have to do that. Don't send original documents if you are sending things through the post. Always send photocopies, or if you're sending it electronically, obviously you can send it as scans, and make sure that you keep a copy of everything that you send, including your original SEND 35 form. So once your appeal is lodged, the tribunal will then register it. They aim to register that appeal within 10 working days. So once they've registered it, you will then receive a pack of information, which is usually via email, and that will give you the date of the hearing, so when the case is going to be heard, case directions, which is a lengthy letter but contains a timetable within it of what will happen when, and within that there are some deadlines which you will be expected to meet as well. So you need to make sure you've read that and you can have made a note of when your deadlines are, and there will also be deadlines for the local authority for the actions that they have to take. There is also a right to request your appeal to be actively case managed. So that is where you might ask for a judge to look through the evidence and all the information prior to the hearing so that they can ask for specific information if they feel it's needed. You have something called an attendance form, and you'll have a date by which you have to send that back, and that is where you have to list all of the people that are the tribunal hearing on behalf. So that could be yourself and anyone who's attending with you. And if you are having any witnesses attending as well, you would need to list them on that attendance form. And then you have something called a request for changes form, which is a SEND 7, and you can also get those from the SENDish Tribunal website as well. So those can be used throughout the tribunal process if there are any changes that need to be made to the appeal as you go along. At the same time, the tribunal sends the local authority a copy of the notice of appeal, along with the date of the hearing and their case management dates, etc. And they get their attendance form and request for changes forms at the same time. So once you receive your case directions and your pack of information from the tribunal service, that's the point at which the local authority will also be made aware that you've lodged that appeal. So this is a timetable of what should happen. So within the first 6 weeks is when the local authority must respond to the tribunal and to the parent or young person, and they must say what they agree with, what they are resisting, and the legal points they're relying on. And if it's about a placement in section I, they must also include the costs of any placements that have been requested or suggested by the local authority. So essentially what you would get is a copy of the form that the local authority sends to the tribunal that will tell you what they think about your reasons for appeal. So they'll say whether or not they agree with what you're saying, they'll say whether or not they disagree with what you're saying, and they have to give their reasons why they disagree if they do. The final deadline for all evidence to be submitted will be week 8 in the process, and in your case directions you will get specific dates that tell you when your week 8 is. So you must try to make sure all of your evidence is into the tribunal by that point, and all evidence must always be sent into the tribunal service and also to the local authority. Every time you send something in, it must go to both parties. By week 9, all parties must have sent in their attendance form, and the local authority then issues what's called the evidence bundle. So that's just all of your evidence and all of the local authority's evidence put together and into a bundle, and that's what the judge will get and that they will read before the tribunal hearing. The hearing happens at about week 12, and then you usually get your decision following the hearing by about week 14 of the process. So I'm going to talk a little bit now about preparing the case before the hearing. So as I said earlier, it is an evidence-based process. So whatever you are asking for, whatever your reasons are for appealing the decision you're appealing, you need to have evidence to back up what you're saying. So it's important to make sure you obtain any written evidence and submit it as soon as you can, and definitely before the evidence deadline that we've talked about in the case directions. And all evidence that you submit must be sent to the tribunal and to the local authority. So the tribunal will not allow there to be any surprise evidence. So you can't keep anything back and think, oh, I'll just let the LA find out that I've got this piece of evidence on the day. It must all be sent to both throughout the process. If you're having difficulty getting any information which you feel is relevant to your case from the local authority, you can use one of the SEND 7 forms I mentioned earlier, which is the request for changes forms, to write to the SEND Tribunal explaining what it is that you're asking for and asking the SEND Tribunal for a direction to make the local authority release the document. So that would be where a judge would look at it and decide that that piece of evidence is necessary, and they would order the local authority to make it available. And the tribunal will do that unless there is a very, very good reason why the local authority doesn't want to. If you know that there's an assessment or a report that will not be available until after the evidence deadline, then you need to let the tribunal know and ask for an extension. So that again would be using the request for changes form. It's possible to apply for late evidence to be submitted after the evidence deadline, and on some cases they will allow you to bring late evidence on the day of the hearing, but that is up to the tribunal judge as to whether or not they would accept that. So it's best to notify them of any late evidence as soon as possible. So when you're thinking about your evidence, you need to think about, is it up to date? So the judge will be looking for it to be approximately within the last year. That's not a strict rule, but they don't want to know. So if your young person is now 14, for example, they don't want every piece of evidence that you've got or every piece of information you've got about your child from when they were 5. They need to know what the current situation is. So it needs to be up-to-date evidence. You need to think about, does it address the issues that you're appealing? So does it show all the things that you think it needs to and make sense for your argument? Does it support the points that you're making? So if you are saying that your child or young person needs a specific placement in a specific school, your evidence needs to show why that's the case. The judge will be looking at the evidence that is available and making decisions based on that. So it's really important to think about the evidence that you're sending in. So you can have case management. You can ask for case management, but the tribunal judge can also call case management meetings at any time throughout the process. And they often do that if it's a complex case or there are issues which need to be sorted out before the hearing. Sometimes they will call a telephone case management hearing just to make sure everybody is ready for the hearing and that all the information is there that they need. And it's an opportunity for them to consider any preliminary issues which need to be sorted out before the hearing can be held. So if it's thought that further assessments perhaps need to be carried out to for the judge to decide whether or not a certain point is correct, or when one party wants to postpone the hearing but the other doesn't, and it can also help to narrow down the issues that are in dispute. So sometimes some of the issues can be sorted out through case management and just leave the main issue for the hearing day itself. If there's a matter which needs to be resolved before the hearing, you can make a request for a telephone case management hearing yourself using the request for changes form. So you do have an opportunity to have witnesses, so both parties can have witnesses. So you could have your witnesses and the local authority can have theirs, and you have to notify the SEND Tribunal of who will be attending using the attendance form by the deadline in the case directions. So you may need to make sure that your witnesses have agreed to be witnesses. You can't just name people on the attendance form. It's not the tribunal's job to call the witnesses to the tribunal hearing. That will be up to you to sort out. You need to make sure that any witnesses that you choose are able to give evidence that is relevant to your case as it stands. You need to think quite carefully about who you ask. All witnesses will be asked by the tribunal about the facts of the case. So their role is to not be arguing one side or the other, and you shouldn't worry if someone from the child or young person school or college is asked to attend as a witness by the local authority. That doesn't necessarily mean that they're on that local authority's side. They are just going to be asked about the facts. So often in appeals around section I, there will be somebody from the school that the local authority is saying is the correct school, and somebody from the parents' preference school in attendance, so that the facts can be established around which school is the most suitable. If you've got a witness that you really want to be there because you think that they're crucial to your case, but they are refusing to attend, you can ask the tribunal judge to summons the witness. However, you need to be aware that if you do that, it is your responsibility to hand deliver that court summons to the witness. And I would be mindful of the fact that if they don't want to be your witness, are they going to say the things that you want them to say in the hearing? But it is an option if you're struggling to get someone to attend as a witness. So with every tribunal hearing, you'll have a hearing bundle, which, as I said earlier, is essentially all of the evidence that both parties have sent in, put together in one pack of information. And that's the local authority's responsibility to create that evidence bundle. And they have to do it in a certain way, and they have to index it and format it in a certain way in line with the guidance from the tribunal service. There are limits as to how long the bundle can be depending on the type of appeal, and you can find that information in the SEND Tribunal's bundle guidance, which is on the tribunal website. So again, when you're thinking about your evidence, you have got restrictions on how much information is allowed to be included in the bundle. So it's about making sure that what you send in to be included is the most important and most relevant information. The local authority must include all of the evidence that the parent or young person has sent in, but it's always worth checking that bundle through before the hearing, just in case anything has been left out. So when you get that bundle, go through it and make sure it includes absolutely everything that you've asked to be included as evidence. If you've sent in too much information and it does go above the page limit as set out in the tribunal's bundle guidance, the local authority needs to still include that, because it will be the tribunal's decision whether or not it's going to be considered. So the hearing itself, I'm going to talk a little bit about that. So you won't be surprised, I'm sure, to know that currently everything is being done virtually due to the pandemic situation. So tribunals haven't stopped at all through the coronavirus lockdowns. They've continued right the way through, and they've all been done via a virtual platform. Before that, and I don't know whether that will go back to that once we're out of this situation, hearings were held at a venue that is within 2 hours of where you live. So that's the general guidance, is that they will hold it as close to you as possible, but it will be within 2 hours of where you live. Each tribunal will be made up of a judge, so you will always have a judge, and they will always have with them at least one specialist member. Sometimes they have two, but there will be at least one there with them, and those are specially trained people that work for the tribunal service that also have an expertise in SEND of some description, and they will pick the specialist member that best suits the case that is being heard. There will also be a local authority representative, so somebody either from the local authority, or sometimes they will use a solicitor, will be there to represent the local authority. And there will also be obviously any of the witnesses that have been named on either attendance form, whether that's your attendance form or the local authorities. And then you and any representatives or supporters that you have named in your witness statement. There won't be anyone else there. Those will be the only people in the room. We're often asked about children at the hearing, so I think it's crucial that children and young people's views are needed, and they should be submitted as part of the evidence process. So at some point through that evidence process, we need to try and make sure that the child or young person's views are captured and submitted. If they want to and are able to speak at the hearing, then that will be done in a way that is much less formal than the hearing itself, and they will just usually speak to the judge and the tribunal members rather than everybody that's in attendance. But when we are back in the world where we are attending hearings in an actual venue, the children are not permitted to stay in the tribunal hearing room for the whole day, and there's no childcare available. So you would need to have someone there to look after the child or young person while the hearing was continuing. So just a bit about what a hearing itself is actually like. So they do try to make it as relaxed as informal as possible. However, it is a legal process, so there is still an element of formality about it. It's highly likely that as a parent or carer or a child or young person, you're going to feel emotional, but it is important that you wait until you are asked to speak. So everybody will be given their opportunity to speak, and the judge will make sure that you get to contribute as much as the local authority, and they are very good at doing that. But you do need to wait until it's your turn. So it's really important to try and keep calm and don't talk over people. So when it's a virtual hearing, which they all are at the moment, you need to make sure that you're in a quiet space where you won't be disturbed as much as possible and can concentrate on what is being said. However, the tribunal do acknowledge that, you know, we're in a situation at the moment where if we're having to have hearings in a lockdown situation, there will be other people in the house, and it might be some disturbances, but if you can keep it as minimal as possible, then that is great. So you need to know your evidence bundle and where to find the evidence that backs up your points. So when the tribunal is in full flow, when the hearing is happening, people will be making references to the tribunal bundle. So it's important that if you've got any key points that you want to bring out, that you know where in the evidence to find those key points so that you can show people where they are. And if possible, just try and prepare a summary of the main points that you want to make sure the tribunal has heard. So have them ready so that at the end of the hearing itself, you can just make sure all of those main points have been heard by the judge and the specialist members. Very, very occasionally, the tribunal may give a decision orally at the hearing, but generally it's provided at a later date and in writing. So just to manage expectations there, you don't usually get the decision on the day. But either way, the SEND Tribunal will provide the parties with a decision notice stating the SEND Tribunal's decision, written reasons for the decision, and notification of any rights of review or appeal against the decision. So first tier tribunal decisions can only be appealed against on a point of law. So the only way that decision can be appealed is if you can evidence that some way, and this will also include the time within the application for appeal must be lodged. Generally, you receive that within 10 working days of the hearing date. If the SEND Tribunal orders the local authority to carry out an action, so for example to start a needs assessment or to issue a plan, then there are set deadlines in which they must do those things, and those can be found in Regulation 44 of the SEN and Disability Regulations. I've put some contacts on here for further information. I've obviously put Norfolk SEND Partnership on there, but as I said earlier, if you're not from Norfolk, your local authority will have a SEND service, so they will be able to provide that information and advice and support to you. I've just popped on there as well the information about the first tier tribunal itself. Then IPSI, which is the Independent Providers of Special Educational Advice, their website has lots of really, really useful information on it, and they do also have a tribunal helpline. And then Contact is another useful organisation with a helpline that can provide you with information around tribunal amongst lots and lots of other things. So that is the end of my presentation. So I'm going to stop sharing my screen and see if there have been any questions.
Oh, that's my cue. Thank you, Amy. A lot to cover there. But hopefully with Amy's permission, I'll have the PowerPoint and then we'll upload that to the platform for you to download when appropriate. Yep. Not many questions. Well, we've got one question, Amy. It was from Ellie, and it was, how has the timeline of tribunals been impacted by the current pandemic?
The reality is actually that it's made it much more efficient. because they're being held virtually, so particularly in Norfolk, and I don't know how much of an issue it was across the rest of the country, but I know it was an issue across the rest of the country as well. When we were pre-COVID and hearings were being held in venues, they were often postponed because either a venue couldn't be secured or they couldn't get a judge and tribunal specialist members to travel to the venues that they did manage to secure. So interestingly, one of the benefits of the lockdown situation and has been that the virtual tribunals has meant many less postponements due to problems such as that. So tribunals are tending to be heard within their timeframes at the moment, whereas pre-COVID they were often going over their timeframes.
Lovely, thank you, Amy. Has anyone got any further questions for Amy regarding appeals? Or, I mean, we've got 10 minutes, and I hope Amy don't mind me saying this, but anything to do with an EHC, applying for an EHC or anything along those lines.
No, so that's fine. I've left it early, so we've got plenty of time for questions. So if there's anything at all, I'll be happy to ask.
They're obviously, they feel lost because...
And just while people think about those questions and type anything, are you happy for your email to go into the chat, Amy, or an email for CENDIAS?
Yeah, if you can put our main one in, that would be great. Our main one. Do you want me to do that?
If you can, yeah, because I would have to look it up.
Yeah.
So if you have got any questions after the session or further down the line, or you need some advice, obviously you can email Amy. Just to mention something else that Amy mentioned at the beginning, every local authority should have their own CENDIAS service. I believe that's part of the law, isn't it, Amy?
Yes, it is. Yeah. So it is statutory that all local authorities have a service the same as mine.
So if you're not in Norfolk with us, like I know a lot of our participants today aren't, there will be a very similar service locally that you can access that should be independent from your local authority and help you in any of your appeals or even just advice around an EHC. I think someone's just typing, so I'll give it a minute.
So things like, as we were saying at the beginning, like, mental health affects.
I'll pop our
lots of us,
website in the chat as well, so that
that's
there's lots of information on there as well.
There's lots of information on the CENDIAS website, and it's available in easy read format, because a lot of it, because it's legal, it can get quite jargony, can't it? So Maria has just asked, who can support an EHC application process where school declines to do it, please? Daughter has ADHD and ASD, but school not sticking to the learning plan.
So your local CENDIAS service should be able to support if you want to do a parental application. So if the school has declined to do it, then a parent can apply in their own right anyway, and then the school will be asked to provide.
Okay. Sorry, Amy, you just broke up halfway through that. So could you repeat that for us? Thank you.
Sorry. Yeah, so I was just saying that so a service such as mine, so the local CENDIAS service to wherever you are, would be able to support with that, because the parent can apply for an EHCP in their own right. They don't need the school to do it, and once the parental application goes in, the school will be required to provide all the same information anyway that they would have done in an initial request.
Lovely, thank you. And that application form, it differs between different local authorities, doesn't it, Amy? But it can normally be found on your local offer page, your Send Local Offer.
I'm just popping a link in the chat to where you can find, if you're not from Norfolk, where you might be able to find out who your local service is, your local CENDIAS service as well.
There you go. Oh, so Council for Disabled Children. Yeah. Lots and lots of stuff on there. Lovely. Okay, so if there's no further questions for Amy at this point, feel free to email. Amy provided her address in the thing. Maria's from Norfolk, so I presume you'll probably be getting
she can give us a call or contact us and we can help with that.
Lovely. I presume you'll probably get a phone call very shortly. But thank you, everyone. Thank you, Amy, for coming along and giving us your time in the talk. Feel free to email any questions afterwards. But yeah, thank you very much. Got about half an hour till our next set of talks. They're your last sets. So feel free to have a look around the rest of the platform if you haven't been able to. The forums are still open, so any questions can go on there and I'll pass them on your behalf as well. So once again, thank you, Amy.
Thank you.
And we'll see you all in the next session.
Bye.
But you'll have to end the chat, Amy, because you are the
Okay.
host.
No worries.